Hello and welcome back to another session of Back to Basics. Today is the second session in the subject series of Law of Torts. In the first session, we saw an introduction to the concept of torts where we understood the meaning of torts, the essential of torts, the characteristics of torts, and many more things such as some legal maxims. In today's class, we are going to extend that particular information and we'll have a very quick recap of what we studied in the previous class. And then today we'll be covering an important aspect in this subject, which is general defenses. What are the defenses if a person commits a tort? What can be the possible defenses which he or she can claim in order to escape liability? Right. So let's begin without any further ado. Also, very important, in case you have any questions related to the first class or this class, please feel free to drop them in the comment section of this video and I'll be very happy to answer them. Even if they are questions related not related to law of torts, you can still ask them in the comment section and also give your feedback on this particular series and these videos on how we can bring more things for you, how we can make this better for you. I would await for your feedback. Okay, let's begin today's class. The presentation is visible on your screen. Let's start with our discussion for the day. So, first of all, let's go back a little bit and understand what were the essential of torts. Now, torts, as we all now know, is a civil wrong. It is a wrong which is different from a breach of contract or a breach of trust. And the literal meaning of the word is something which is twisted. Right? We do not have a codification of the law of torts in India. That means there is no rule book or there is no written law with respect to what exactly is a tort or what is not. It is defined in the Limitation Act, which we saw in the previous class, but there is no codification. That being said, we still have some essential components to understand what exactly is a tort. And these are the three essentials which you can see on your screen. Firstly, there has to be a wrongful act, which is a civil wrong, which means it is different from a criminal wrong as well. The differences as well between tort and crime is what we studied in the previous class. So make sure that you watch that video as well if you haven't yet to understand the difference. Then the second thing is violation of legal rights. There has to be a violation of legal rights in order for it to be called a tort. Remember, we studied two different maxims in the previous class, legal maxims or legal phrases, injuria sine damnum and damnum sine injuria. So the injuria there was referring to the injury of legal rights, right? Not an actual injury, but an injury to your legal rights. So there has to be violation of legal rights and there has to be legal damage arising out of it. What type of legal damage? We also studied that there can be three types of legal damages arising out of a tort. What were these? Three types were damage to person, damage to reputation, or damage to property. So the three different types of legal injury which can cause damages and thus result in a law of tort, right? So what are the legal damages? It were damage to person in form of assault or in form of battery, which is use of physical force, in form of defamation, in form of false imprisonment. It could be reputation related, which is again related to defamation, or it could be related to property, such as nuisance, such as trespassing on a property, such as committing a fraud, misrepresentation, multiple other things. So this is how we understand that these are the three important components, and these are the classifications of types of legal injury that can happen. Now, of course, we'll study the different type of torts. We'll study assault in detail, battery in detail, defamation in detail, false imprisonment in detail, nuisance in detail, trespassing in detail, fraud in detail, and there are many more as well. This is not an exhaustive list. But before we go into the depth of all of these different torts, it is important to understand what are the defenses to these torts, right? What are the general defenses? Why do I call them general defenses? Because they are not just specific to a single tort. These apply to all of these defenses, be it related to person, be it related to property. What is a defense? A defense is a escape from liability. A defense is something which provides you immunity from liability so that you are not prosecuted under the law of torts. So let's talk about the general defenses. They are classified into 8 different types. There are 8 defenses under law of torts. The first one is voluntary non-fit injuria. The second one is plaintiff the wrongdoer. The third one is inevitable accident. The fourth one is act of God. Fifth is private defense. Sixth is statutory authority. Seventh is necessity. And eighth is mistake of facts and law. Now, these might seem very difficult terms or alien terms or things you have not heard of before, but there's nothing to worry about. We'll discuss all of them in detail in today's specific class, in today's video. We are going to discuss four of them, four out of the eight, the first four, and talk about them in detail with examples so that you understand them better. So I hope we are ready to begin. Ciao, let's start. When you talk about the first one, voluntary non-fit injuria, what do you understand from these words? Have you heard of the word voluntary? No, you probably have not. But have you heard of the word voluntary or voluntarily? It means by your own discretion. It means by your own will when you do something voluntarily, right? And involuntary is without your will or without your discretion, correct? So, voluntary non fit injuria. This is a Latin maxim, which means that if you are willing to participate in a particular activity or in a particular act where you know or understand the risk involved, then if an injury happens to you, you would not be able to, say that this injury happened to me, now give me compensation under law of torts, which means that you were willing to take that injury, you were willing to put yourself through that sufferance, right? And therefore that harm which has occurred to you would not be liable for compensation. A very famous and very good example for this particular general defense is, let's say you go and watch a cricket match. Okay, now you go and watch a cricket match in a stadium. I'm not talking about in your drawing room. In a cricket stadium, you watch a cricket match and Virat Kohli hits a six, although his form is really bad. But let's assume he hits a six and it comes and hits your head. This is hypothetical. I don't want you to get hit on your head. Let's assume it hits your head and you suffer an injury because of that. Now you file a case on the stadium authorities and Virat Kohli and BCCI and everyone that you should be liable for compensation because you have suffered an injury and you filed a case of battery, that this is a physical harm to your body, correct? Now, would you be held? Would you be given compensation? The answer is no. Why no? Because when you go and watch a cricket match, you understand that there is a risk of a batsman hitting a sixer and that coming and hitting you. So you voluntarily participated in that activity, well knowing the risk. Same goes for other activities like a football match, or if you would have watched, bullfighting. Even if in videos or in documentaries or movies, that people sit around a bull pen and bulls fight, or a person tames the bull, and sometimes the bull charges in the audience. Can those people really bring about a case saying that the bull has injured them and now they want compensation? No, they willingly agreed to that injury. So in this case, in certain cases where you are willing to participate in an injurious or possibly injurious act, and when the person suffers willingly, no harm is done. This is what the literal meaning of this maxim is, that the person themselves consents to the harm. So इसके चार essentials हैं. Consent should be free. You should be giving your consent with your own will, without an external influence by anyone. कि आपको किसी ने let's say gun point पे बोला कि जाओ क्रिकेट मैच देखो, या आपको धमका के बोला, कोर्स करके बोला, that is not free consent. Your consent should be free. You should have the knowledge of the risk. If you are not having the knowledge of the risk, then of course you can claim that I did not know that this might possibly happen. Then you should have voluntarily accepted the risk. If you would have not voluntarily accepted, then again you can claim damages. Then there should be decision making capacity. That is, again, your consent should not be as a minor or from a unsound mind, because you need to be a major and a person of a sound mind. So if these four essentials are satisfied, which they are in that cricket match example case, the cricketer, let's say Virat Kohli, can claim this defense of voluntary non-fit injuria, that you voluntarily suffered that injury. You were willing to suffer that injury. That's why you came to watch the match. Exceptions here are rescue cases. Why? What do we understand by rescue cases? Let's say that a person is drowning in a river, and then you jumped into that river to rescue that person. In that case, of course, you are putting yourself to a risk or to an injury, because you can also drown, but this is an exception to this exception. So exception का भी exception है. इस case में compensation मिल सकता है, even if you are willing to participate in the risk, because you are rescuing someone, you are doing it for a greater good. Okay, so that is the defense of voluntary non-fit injury. It's very simple. We'll also do questions on all of these defenses so that you understand these things better with more examples, but that is in due course of time. Then, plaintiff the wrongdoer. That is the second defense. What do we mean by plaintiff the wrongdoer? Now, this is a little bit similar to the first one, where you are, let's say, consenting or willing to take the risk. Here, you are actually doing a wrong thing. For example, okay, chalo, let's read what is written. A person conducting wrongful actions cannot seek compensation for the harm or injury arising from the conduct. Plaintiff must come to the court with clean hands. So that means if you are going to the court to claim compensation for a wrong which has been committed to you, ऐसा नहीं होना चाहिए that you are also in a wrongful position. I'll give you a very valid example of this one, very pertinent example. Let's say you are driving in a one-way street on the wrong direction. Okay, so let's say this is a road where only traffic can go from this side, and you are coming on the wrong direction. You have your headlights on, you are blinking your horn, but you are coming in the wrong direction on a one-way road. And there is a guy who is drunk and driving his car, and due to his drunk driving he rams into you. So you can say that, okay, now I have suffered injury, or my car has suffered injury, so I should be able to claim compensation from a drunk guy. No, you are also the wrongdoer for coming into the lane from the wrong side. So that means you are not with clean hands. You are also having a wrongful action on your part. And that is why you cannot claim compensation. Very simple, very straightforward. There is a maxim which talks about this: ex turpi causa non oritur actio. That means if you are committing an immoral or illegal act, which is turpi causa, there would be no action which would be arising. No action arises from an immoral or illegal act. Simple as that. Nothing complicated here. So this is the second defense. Plaintiff, the wrongdoer. Plaintiff, we remember, is the person who makes the complaint. So if you are the plaintiff, or you're making the complaint or the plaint, then you need to be going with clean hands. Simple. Okay. Let's move to the next one, which is the third defense, which is inevitable accident. Now, what do we understand by inevitable accident? What is inevitable? Inevitable is something which cannot be prevented, which cannot be foreseen, which cannot be calculated beforehand, which you cannot, even with ordinary care or caution or skill, you cannot prevent something. अगर हो गया एक्सीडेंट तो हो गया, वो आपके कंट्रोल में नहीं था, वो आप उसको पहले से नहीं समझ सकते थे कि ऐसा हो जाएगा. Okay, so another example of this could be, let's say, all right, so let's again take a road example. Let's say you are going on a road driving in your car, and suddenly a kid comes running on the road, and you press the brakes really hard, but your car swerves and hits another car. Okay, so in order to protect this particular child, you meet with an accident with another car. Now this car obviously gets damaged and wants to claim injury, wants to claim damages. But would he be able to claim damages? No, because this was an inevitable accident. That is, it could not be possibly foreseen or prevented by the exercise of ordinary care, caution, and skill. So आपने ordinary care भी करी, आपकी गाड़ी की ब्रेक्स चल रही थी, you were attentive, you were not over speeding, you were cautious to prevent the child, and you used your skill in the best manner you could, but it still resulted in an accident which was inevitable. So this is how you would escape liability. You would not be liable to pay damages to this particular car. Correct? Another example of this could be, let's say you were walking in a forest, you were on a hunting expedition. Okay. In a hunting expedition, when you shot your gun towards let's say animal, let's say a deer, the animal quickly jumped and it dodged the bullet, and the bullet hit a tree. And by hitting the tree, the bullet got deflected in such a way that it went into a different direction. And in that direction, far away, a person was, let's say, standing. You were unaware of that person. You did not know there was a person there. And that bullet, after hitting this trunk, deflected and hit that person and injured that person, or let's say killed that person. Would you be liable for this particular injury? No, you would be not, because you exercised ordinary care and caution. You saw that there is no one nearby, and you were, let's say, in a authorized hunting zone. You were proceeding with caution and skill, but due to an accident which you could not have foreseen or prevented, this person suffered injury. So in this case, he would not be liable to claim damages, and you would not be liable to give damages. Okay, so this is the defense of inevitable accident, an accident which you cannot prevent. Okay, now moving to the fourth defense and the final defense for this particular class is very interesting. इस पे movie भी बनी है Bollywood की, which is OMG, the first one, act of God. Now, something which is beyond your control or caused by natural forces is called an act of God. It's also called vis major. That means a force which you cannot predict or cannot defend from. So, vis major is a Latin term which means superior force. This defense arises when the damage is caused by a natural force and without human intervention. दैट इज उसमें किसी ह्यूमन का पार्टिसिपेशन नहीं है, वो नेचुरल फोर्स की वजह से नुकसान हुआ है, एक्ट ऑफ गॉड की वजह से. इसके तीन एसेंशियल्स हैं. वर्किंग ऑफ नेचुरल फोर्सेस विदाउट एनी ह्यूमन इंटरवेंशन, ऑकरेंस मस्ट बी एक्स्ट्राऑर्डिनरी. दैट मीन्स ऐसा नहीं कि नॉर्मल कोर्स ऑफ इवेंट्स में भी वो चीज़ होती रहती है तो फिर आपको एक्ट ऑफ गॉड का डिफेंस नहीं मिलेगा. मैं एग्जाम्पल्स के थ्रू समझाऊंगा अभी आपको. could not be anticipated or reasonably guarded, मतलब उसको पहले से प्रिडिक्ट नहीं कर सकते थे या उससे बचाव नहीं कर सकते थे. Fair? Now let's understand through examples. Let's say that you have a neighbor who has a wood business, okay? ये वाला लकड़ी वाला wood business, and he has a storage warehouse. Or let's say you have a storage warehouse where he asks you to store your wood, and he is going abroad for a, let's say, vacation or for some work. Then he asks you to keep his wood safe in your warehouse from any damage or such things, correct? So you are responsible for his wood, for the safekeeping of his wood. Now you kept his wood in your safe warehouse, and suddenly one day, very I would say very damaging and very torrential rain came with tornadoes in a region which is not even known for tornadoes or torrential rain or heavy rainfall. Let's say you are living in the Sahara Desert, okay? This is where it happens. A tornado comes and very heavy downpour comes. As a result, the wood in your warehouse, which was not, let's say, guarded from the roof, the wood gets destroyed. Now, would you get the defense of act of God? Yes, you would. Because you could not have foreseen, you could not have, by any intervention, predicted that such a thing would happen, that a tornado would come in the middle of a desert. So this is act of God. Natural force without human intervention, extraordinary occurrence. Cannot happen in ordinary day-to-day occurrence, right? And cannot be anticipated, cannot be reasonably guarded. Simple. So you get the defense of act of God. Now let's say the same thing happens, but in Meghalaya. Now, if your geography is even decently good, you would know that Meghalaya gets a lot of rainfall throughout the year. Now, in this case, can you take the defense कि मैंने छत नहीं लगाई अपने warehouse में या my warehouse, I could not protect the wood from rain because heavy rainfall happened. No, you cannot take the act of God because this is not an extraordinary occurrence. This is an ordinary occurrence in Meghalaya. That rainfall would happen. Heavy rainfall does happen, and you can anticipate it. You can reasonably guard from it by taking measures, right? So although it's a natural force without human intervention, but it's not extraordinary or not something which cannot be anticipated. So simple way, that has to be natural force, has to be extraordinary, and has to be unanticipated or unpredictable. And if all these three criteria are satisfied, you can get the defense of act of God. जैसे आपने OMG मूवी में देखा होगा कि जो बिजली कड़कती है, लाइटनिंग, उससे सिर्फ एक बंदे की दुकान, जो कांजी भाई होते हैं, उनकी दुकान को नुकसान हो जाता है, बाकी दुकानों को कुछ भी नहीं होता. So it was an extraordinary thing that lightning happened only on his sort of warehouse or godown or shop, whatever. He could not anticipate it. He could not reasonably guard himself. It was natural force without human intervention. And that is why he said that God should pay compensation, and the whole act of God debate happened, that whether God can be held liable or not. So this is a defense in the law of torts. Okay, this is also a defense in a lot of contracts, by the way. When you'll study contracts, we'll talk about this again. कॉन्ट्रैक्ट्स में क्लॉज होता है एक्ट ऑफ गॉड का कि अगर कॉन्ट्रैक्ट फ्रस्ट्रेट हो जाता है या पूरा नहीं हो पाता बिकॉज एक्ट ऑफ गॉड, तो कोई भी लायबिलिटी नहीं होगी. So yeah, these are the 4 defenses which we are going to study today. If you have any doubts in these defenses, please let me know in the chat box. The first one was voluntary non-fit injuria. You suffer willingly, put yourself to the risk. Plaintiff the wrongdoer, you doing the wrongful action and then going to the court. Inevitable accident, an accident you cannot foresee or prevent. And lastly, act of God, something which is by natural force without human intervention and extraordinary. And these are the 4 defenses which we studied in this particular class. In the next class, we'll study the remaining 4 defenses, which is private defense, statutory authority, necessity, and mistake of facts in law. So stay tuned to the channel for the next video. Do drop a like on this one, share it with your friends, and don't forget to subscribe to the channel as well. And I'll see you all in the next one. Till then, take care, keep learning. Bye bye. Signing off.